we want to get to the latest in the Bryan Kohberger trial. That trial going to be delayed after all. Kohberger waived his right to a speedy trial during a court hearing just yesterday, pushing back the trial start indefinitely for now. Joining us to break down what this means is legal analyst, friend of the program, Jacqueline Goodman. Jacqueline, of course, a lot of people that we have talked to, including yourself, expected that this trial would be delayed. But are you surprised that it took so long for this move?
No. I think that we all did really expect that he would waive his right to a speedy trial. And in Idaho, they have a right to a speedy trial within 6 months of the date of the arraignment. And so they do have time to figure out whether or not they think that's the right strategy. Generally speaking, if somebody's out of custody, they're going to be waiving their right to a speedy trial to allow their attorney time to prepare. But when you're in custody, that's not always the case. And so, it takes a little bit of time to figure out whether or not you really have to waive that right.
Can you just explain to our viewers a little bit the terms that a speedy trial requires, just so we can get a better understanding as to why Kohberger denied this right?
Yeah, so the United States Constitution requires that we all have a right to a speedy trial. So you can't just linger in custody, generally speaking. So there are some notable exceptions, Guantanamo being basically it, where folks wonder how it is that the Constitution be suspended. But in our everyday lives, the states have to comport with that requirement, and every state has a different way of doing it. And so in the state of Idaho, they allow a defendant a right to a trial within 6 months, and that is enough to comport with the constitutional requirement and the state statutory requirement, the state constitution requirement in Idaho. And so the defendant has that right, and the defendant can waive that right. What's interesting about Idaho, which is different from the majority of other jurisdictions, is that once you waive your right to a speedy trial in Idaho, you sort of waive it for good. It's not that they can just languish in custody eternally, but it's really one waiver. And so that's why you see the judge taking particular pains to make sure that he fully understands the rights that he's waiving. And it's a pretty big decision, whereas in other jurisdictions like in California, where I am, you waive that right incrementally. So it's not that big a deal when you say you can bring me to trial in 10 extra days, and we'll talk about it again then. So in Idaho, it's kind of a big deal.
Is it still too early to speculate when this trial could start?
It is actually a bit early to speculate on a particular date. So as long as we're not, in Vegas, I'm not going to be placing any bets on it. But what I can tell you is that in a case this serious, this is a capital case, and it's nothing to make light of. Really, the defense, in order to make sure that they're providing us an efficient and complete defense, that they're looking at every possible avenue for a possible acquittal, they've got to do their job. And so that takes some time. It takes time to do investigation, and it takes time to find experts and determine the theory of the case and the theme of the case, and get ready to really put your best foot forward, because you literally have somebody's life in your hands. So when they push the trial back in increments of 37 days, for example, I don't think anybody takes that all that seriously. But it's hard to say whether this is going to be months or years. I know that the victim and the victims' families have been pretty vocal about their concern that this would go on for years and years and years. And really, that's unlikely in this case.
Jacqueline, there was a motion hearing just last week, and when the judge ruled that this trial would not be delayed. So why all of a sudden the reversal?
Well, because the defendant at that time hadn't yet waived his right to a speedy trial. And so the court was having to make difficult decisions and make sure that he had the lawyers on track to get this trial to the jury in a timely way. And this now, given the good cause that Ann Taylor, his lawyer, has shown, and the need that he has in this very serious case for more time to prepare an adequate defense, there's no way the judge was going to deny him that.
You did mention briefly the victims in this case. I'm going to pull up some photos of those 4 victims, and the fact that their family is very concerned right now because they don't want this trial to last 4 years. They're just trying to get some closure. Does the judge consider what the family is going through when it makes this decision about delaying the trial?
Yes. After 260 years of jurisprudence, generally speaking, criminal defense cases or criminal cases were the government trying to take the liberty and even the life, as is in this case, of a citizen. Here, though, what we've seen is some of the effects of what we call Marcy's laws, or laws that are designed to give voice to the victims in these cases. So those kinds of ideas really kind of change the dynamics of a criminal case. But what happens now is that virtually in every jurisdiction, they have these kinds of protections. The victims in cases do get an opportunity to be heard, to know about things that are changing as these critical stages come up and these changes occur. They get notice. Now, statutorily and sometimes constitutionally, they're right to have notice about what's happening. And so judges do listen to what the victims feel and what they're thinking, and the courts will, take that into consideration when they're making their rulings, but doing so in the context of the other considerations in terms of what is fair to the defendant and what is necessary to protect the public interest. So, the judge is definitely going to be listening to what they're saying, and that's for that reason I don't expect that this case, and other reasons, quite frankly, I don't expect this case to go on and on and on for years like they're afraid. And I don't think that it's going to be something that happens in a month either. I think it's going to be somewhere in between. My guess would be maybe a year from now or less.
Finally, Jacqueline, now that this trial has been pushed back, do you expect that the flow of information is also going to stop? I mean, we got a lot more details as these hearings were approaching these past few weeks.
Well, I don't think that the flow of information is going to change, other than the fact that now the timeline is longer, and so lawyers have more time on each side to be bringing motions and to be litigating. And so you may not see something happening every day, but you're still going to see, I think, a lot of litigation in this case. It's high profile. It's something that the entire community is watching, and I think the lawyers are quite well aware of that. They're going to be put to task. I think the judge is going to hold them on a tight leash, and I think they're going to have to be litigating this case pretty quickly, and I think you're going to see a lot of information coming through.
Jacqueline Goodman, criminal defense attorney, friend of the program, we thank you so much for joining us here at LiveNOW from Fox and being one of our go-to people when it comes to dissecting this death penalty case against Bryan Kohberger. We look forward to having you again soon.
It's always a pleasure. Thank you.